All right, everybody, I'm going to get started. Thank you and welcome on behalf of the American Constitution Society. I'm thrilled to welcome you to today's event, Defending Law School Diversity after SFFA. So I hope that's the event you are looking for. I'm Taonga Leslie, and I'm Director of Policy and Program with ACS. And I'm Director of Policy and Program for Racial Justice with ACS. And I'm also excited that joining me today will be Kristen Thies-Alvarez, Courtney Burleson, Jarius Adams, and our moderator, Markus Reneau. Unfortunately, our fourth panelist, Madushi Pandey, fell sick this morning and she won't be able to join us. Before we get started with the programming, I have a few housekeeping matters. First, there will be opportunities for audience Q&A, so you should see that option in the chat. You can submit those at any time through that. For CLE credit, you're going to need 2 codes. I'm going to provide those over the course of the event, but you can take the first one now. That code is ERA, E-R-A. There's also going to be a short survey in the chat at the end of the program, so please do take a few minutes to fill that out if you can. We'd love to hear from you about how you can continue to improve our programming. And last but not least, if you enjoy and benefit from today's event, I hope that you will all consider becoming members of ACS so you can continue to deepen this work in our campuses and communities. Which brings us to this event. Part of ACS's mission is to redress the founding failures of our Constitution and enduring inequities in our laws. And one of the places that we see that is in the very structure of our legal system. We have a legal system where people of color only make 20% of our profession, even though people of color comprise about 40% of the US population. And that disparity is one of the reasons we see disparities in how our laws tend to be interpreted and applied. And so we know that the road to a more diverse legal profession, a more equitable America, starts with diversity in our law schools. And this is absolutely an all hands on deck moment for the progressive legal movement. Of course, this summer, we saw the Supreme Court's attack on affirmative action with SFFA. And just yesterday, Edward Blum, the activism behind SFFA, filed lawsuits against major law firms Perkins Coie and Morrison Foerster, attacking diversity programs there. So this is hugely a moment of challenge. At the same time, ACS is very determined. We're in this work for the long haul, and we're so proud to have the expertise that we have in this room. I'd like to introduce our panelists, give you a little bit about them. First up, we'll have Kristen Thies-Alvarez. She's the Dean of Admissions and Financial Aid at the University of California, Berkeley School of Law. She graduated from UC Berkeley, earned her BA with high honors in Rhetoric and Native American Studies, and went on to get her JD from Stanford University Law School. From 2006 to 2007, she was a coordinator with the Building Young Minds Scholarship Program for the Habitat for Humanity East Bay, which was a scholarship program serving low-income high school students. And she's been law school admissions dean and financial aid in Berkeley since 2007. She's deeply involved in national law school admissions community and leadership. She serves on the LSAC committees, including the Newcomers Conference Planning Committee, Services and Programs Committee, and is in her 4th consecutive year as member of the Board of Trustees as chair for Diversity, Equity, and Inclusion Committee. So she's got depths of information on this. We're joined by Courtney Burleson, who's the Director of Foundation Relations and Legal Academy at Americans United for Separation of Church and State. She oversees fundraising and institutional donors. Before joining AU, she spent 5 years with the grants program right here at the American Constitution Society. So we're so glad to have her back. She's also worked as an attorney in public defender's offices in DC, California, and New York. She's held positions on the DC Sentencing Commission, Vera Institute of Justice. She received her JD from University of California, Berkeley School of Law, and got her bachelor's and master's from AU, American University. And she attended UC Berkeley for law school shortly after California passed Proposition 209 that abolished affirmative action in California. It decimated Latino and Black representation at California universities, and she was actually the editor-in-chief of what's now the Berkeley Journal of African American Law and Policy. She served twice on the Berkeley Admissions Committee. So years of lived experience there. We're joined as well on the younger end by Jarius Adams. Jarius Adams is originally from Hattiesburg, Mississippi. He's a 3L at Howard University School of Law. He was elected to serve as the 57th National Chair of the National Black Law Students Association, which is the largest student-run 501c3 in the nation, serves 7,000 law students at 200 accredited law schools, and he's the first national chair from Howard University School of Law. His theme for the year for his administration is Believe in Yourself, No Fear, No Limits. Last summer, he was a legal intern with Assistant Attorney General Kristen Clark from the Office of the Civil Rights Division of the U.S. Department of Justice. Of course, we have our moderator, Markus Reneau. Markus Reneau was born and raised in New Orleans, Louisiana. He attended urban public schools and then completed a BA in African American Studies with a concentration of education and policy from Yale University. After graduating in 2019, Markus traveled to England and served as Yale Fellow with the Oakham School in Oakland, England. And he also worked after his time abroad as an investigative fellow with Orleans Public Defenders. He's now a 3L at Harvard University School of Law. He's passionate about how history nuances contemporary American society and what lasting policy changes can be made to improve our reality as Black Americans. And in his free time, he plays rugby, golf, and runs with his dog, Zuri. So I always feel at the end of those intros, like, obviously we are going to resolve racial equity in this hour. This could not be a more stacked panel. But I thank you all, I welcome you, and I pass it now to Kristen Thies for her opening remarks. And I hope you'll join me in a big virtual round of applause for all our panelists.
Thank you so much for that introduction. I'm really excited to be here, and I'm excited to be amongst these panelists. I think Courtney and I may share something we didn't realize, which is that I was applying to law school in 1996, 97, and making a decision about where to enroll. And that is the year that California passed Proposition 209. So as a person of color, was directly impacted in part with just the great hand-wringing and lack of information that sort of followed in the wake in public schools in California, when there was no longer affirmative action, and essentially schools were figuring out what to do, what questions they could ask. And in many ways, that's where we are nationally again. And so I appreciate the opportunity to be here and be a part of this conversation. I was asked to talk a little bit about the very recent past in terms of the racial and ethnic and other diversity of the class of 2022. So the students that just completed their first year, entering class of 22, their first year of law school, because it was a sort of high water mark, or at least that's what most people think is it's going to be as we move forward in a world where there is no affirmative action nationally. So let me just run down and give you guys some sense of the last class that we enrolled, not the ones that just started this fall, but the ones that started the fall before. The class was diverse in a number of ways. So first of all, let's just say that affirmative action affects more than just people of color. It affects women and others who have been systemically underrepresented, excluded, minoritized, and otherwise not able to participate equally in our institutions, including in our institutions of higher education. So that class was 55% women, or folks who identify as women. Less than 1% identified as trans, non-binary, or genderqueer, but 14% identified as members of the LGBTQIA+ community broadly. There were 36.6% of that class that identified as students of color. To make sure that we're all talking about the same thing, I think it's just important to be clear that what we mean when we say that is using the American Bar Association's definition, and there's actually a more inclusive way to count people. So that number, that 36.6% students of color, actually is not inclusive of people who identified as Middle Eastern, North African. And if you include everybody, the people who were 2 or more, the people who are MENA, in fact, that number jumps up to 39%. So under more inclusive reporting, the class of 2022 was actually 39% students of color. This is a leap forward by at least 2%, even with the more conservative counts, compared to the previous year, which was 34.7%. And again, just in general, a line that's trended upward from 33% in 2018 and 2019 to 34% in 2020, almost 35% in 2021, and then almost 37% in 2022. What I think is also important is we all remember COVID. And so actually that percentage is particularly remarkable because enrollment in law schools kind of right-sized. So there was a huge uptick in enrollment. And so there were many more students of color the previous year because there were just many more students in every category. But this year, the number of students who enrolled was about 38,000, which is typical for first-year law school enrollment, and the percentage of students of color increased within that context. So the representation proportionally also was a big change. I think one of the things that people often want to talk about when they talk about racial diversity in law schools is a conversation that goes a lot like this. Well, if you can only have, better medians or test scores or racial diversity, what are you going to do? Sort of this meritocracy, zero-sum game that people want to imagine happens. And I think it's really critical that we push back on that. Diversity and racial diversity in this context are not at odds with what you might want to construe as merit. And generally when people say merit, they often mean LSAT and GPA. That's a silly definition of merit, in my opinion. But even if we use that, I would just highlight one other statistic, which is that this class that enrolled, which was the most racially diverse class that we know about in recent past, also had higher undergraduate GPA averages and higher LSAT score averages. So this was not a question of the narrative, the prevailing narrative out there in the world that somehow we're making compromises on qualifications for students to admit them who otherwise wouldn't be able to do the work or are not as qualified as someone else. That's simply not the case. The remarkable thing about 2022 was that it was the year that we enrolled the highest percentage of students of color and where we saw increases in both undergraduate and GPA. So those things are not at odds. They are not trade-offs. And in that sense, it is absolutely not a zero-sum game. That being said, I do want to also highlight that those numbers are not, universally perfect for everyone or wonderful. So for example, for Black students, there was actually a slight decline in enrollment when you disaggregate and break it down. It wasn't massive. It was from 7.8% from 7.9%, but students of color also are not a monolith. There are lots of different experiences, lots of different identities, and lots of different ways that they self-identify in a variety of spaces, including in application forms, in their lived experiences, in the journals and organizations that they join, in the work that they do, and so on and so forth. So that sort of sets the stage. I know that you have people who are going to talk about the California experience. I'm so glad not to have to talk about the California experience. Much better coming from someone who lived it at a public law school at the time. But I do just want to point out that the California and some other states haven't had affirmative action in a long time, almost 3 decades. And while we have made lots of gains compared to what really was a stark and terrible era, we have never returned to this kind of racial and ethnic diversity that we had prior to the elimination of affirmative action. So I am often very optimistic, and I talk to a lot of my colleagues about what we can do and what we might look for and strategies that we can use to preserve and protect our commitment to diversity. But I also think it's important to acknowledge that in the decades that followed Proposition 209, while we have come a long way, we are not where we were before the elimination of affirmative action. So I think people's concerns are valid in that sense. I was asked a little bit to talk about what has been effective in driving those numbers, and it's people will tell you lots of things. They'll talk about pipeline programs. They'll talk about a bunch of other things. I'm going to talk about 2 things that I think are important and maybe less commonly talked about. One is just what undergraduate schools are doing. Law schools are at the tail end of the pipeline. We get who finished undergrad, and we get who finished undergrad and had a strong experience in that, who got the courses and the faculty and the mentorship and the research opportunities and the support, whether they attended a primarily white institution or an HBCU. We are the benefactors of the work that is happening in K through 12 education, or not happening in K through 12 education and in undergraduate admissions. And so even schools like in California and like in Michigan who haven't had affirmative action, until this decision from the Supreme Court, was definitely a beneficiary of the fact that there were private undergraduate institutions and public undergraduate institutions in other states like North Carolina who were producing excellent candidates for law school from a range of backgrounds, because then they apply to my school. And so it is not reasonable for me to sit down and say this doesn't impact us because we have Proposition 209. It absolutely will impact us in the way that it'll impact every graduate program, every business program, every optometry program, every medical school, and every law school, because if there are changes at the undergraduate level, we feel those repercussions, and fairly quickly. So it might not be this year, but in several years, if the undergraduate population and demographics change a lot, that will have a direct impact on us. The other thing that I think is important to note just in terms of context is that there were two really interesting conversations that have been happening, and they started prior to the 2022 year, and they've continued, and not just about affirmative action, which became the very loud conversation that happened in the previous 9 to 12 months, but robust conversations about testing and test requirements and about rankings. And you saw a number of law schools that decided not to provide school-specific proprietary information to U.S. News and World Report as a way to, I think, really just expand and embrace a larger conversation about the role of rankings and the way that they were driving decision-making, or could have been driving decision-making, and creating incentives that we didn't necessarily want to have in our system. So you can imagine, if a school is worried about their ranking and they're worried about increasing their LSAT median, and they are operating or laboring under this presumption that means they should only take people who have a certain LSAT score or GPA, that can be extremely problematic for lots of people. And so we've had some really interesting discussions about how to think about the quality of law schools outside of the ranking systems. And then while we still do in law school have a standardized testing requirement, there were just really interesting and robust conversations about the role of standardized testing. And that in some ways came out of what was happening at the undergraduate level as a result of COVID-19, but also it had been picked up by a number of people who've been pushing back on testing for a variety of reasons. While that's not a resolved issue in our space, and people have many different opinions, including that eliminating or keeping, both of which would improve diversity or hurt diversity, right? Like, it's fascinating. Everyone wants to talk about the same issue, but reaches different conclusions. The reality is those discussions are important, because there are people in my role who are reading applications, checking your own judgments and assumptions, and taking the harder approach, which is a very holistic read of files, a very nuanced read of files, and a read of files that looks well beyond scores and GPAs to identify students of incredible academic and professional potential. It was a really unique moment in that so many of those conversations were happening. I'm happy to answer questions about how I think law schools can respond. I want to respect the sort of time parameters that were laid out for us. I think schools are going to try lots of different things, but importantly, they're not trying those things as a way to sort of get around this decision. I think many schools are going back to look at what is our values? What does our mission statement say about the kinds of attorneys we're trying to produce, and the kinds of work that we want, and the kinds of, backgrounds we're seeking to embrace, and the kind of research we want to do, and all of those things, and recognizing that it's not as simple, and obviously it's not even permitted anymore, but it's not as simple as looking at someone who has quote unquote checked a box in a particular way. And so I do think it's going to be a little bit of a bumpy road as schools try to figure it out. Likely some campus councils will be more conservative than other campus councils. I think we're going to see a spate of lawsuits that come out in a variety of spaces. And so it's not going to be a resolved question, but schools are probably doing the important and necessary work of looking back at their core values, mission statements, and how they're reflected in admissions practices, policies, their application forms, their application requirements, and so on and so forth. And I'll stop there.
Thanks, Kristen. We're going to have a lot to talk about at the reunion this year, I think. Thank you, all my panelists, for having this conversation, and ACS for hosting it. It's a real honor to be here with all of you. I wanted to talk a little bit about the strangeness of my law school experience post Proposition 209 that eliminated affirmative action in California. It's interesting to read some of the opinions in the most recent case in Greta v. Bollinger, and kind of the flippancy of comments about this, when discrimination will have stopped at 25 years, we won't have to worry about this, 25 years after Greta, and the idea that the sky wasn't falling at Bolt Hall, that Thomas referred to in Greta, because I think it's really a disconnect from the experiences of the people that were there, and I wanted to talk a little bit about that. It was especially strange, and I kind of miss Medici at this time, because my two top choices were University of Texas at Austin, which at the time had a moratorium on affirmative action, and UC Berkeley. And so there was it was an interesting time to be evaluating what was safe space was for me to be at law school, and navigating what that experience was going to mean for me, knowing that I was going to go into an environment where there had been a thriving, specifically Black community, and that was going to be very different. I think that when I got to Berkeley, and this was several years after 209, so I was, I think, the fourth class after that first class post 209, it was still very much a sense of mourning, because you're surrounded by the reminders of what the campus used to look like, what the culture used to be. But I think there was a real sense of determination and the idea of a legacy that you had to kind of think through and uphold as you went through your law school experience. And I that was both a community building aspect of the environment, especially with the Black community there, but there was also a lot of stakes involved in that I think a lot of people don't have to deal with when they're just trying to pass classes and pass the bar and get their JD, that I think is important. So I went back in my bookshelf and I picked up this book, Silence at Bolt Hall, that really is a great resource of telling the stories of folks both before and after and their experiences. And I recommend it. It's by Andrea Guerrero. And I came across this quote from my former EIC that talks about specifically the journal that I was involved in. And he says, "Our organizations are struggling. We are trying to figure out how to survive with fewer numbers, and we're trying to and learn where our limits are," which was very important to me. He adds, "We need more people at Bolt who are willing to step up and take leadership positions. We don't have the numbers to afford minimal involvement." And I think for me, because I was so overextended in law school in a lot of ways, because I felt that weight of it. At the same time, I remember having a conversation with the ed boards before me about, if not you, then who? Because we were all trying to just kind of make it another day so that we can get an issue out. I was very proud of being able to do the first independent post-209 issue of what's now the Berkeley Journal of African American Law and Policy. And we put everyone's masthead that came before us, recognizing other journals like La Raza that helped us get through that time. And I think that there is a palpable feeling of what that meant to us. I wanted to also talk about some of the isolation that you feel, because there was such a spotlight on Berkeley at the time because of 209, and because Grutter was making its way through the court, because there was Hopwood in Texas. And so there was a feeling of people kind of watching, like, how successful you are. Like, are you up? Like, what is the impact of you being in this environment? I think that kind of stark demographics, we have these small groups that a lot of schools have, our modules. We had 9 of them, but there were only 7 Black people in my class, and we were in 1 in each module. And of course, 2 didn't have them. And there was a real exposure in that I think is also something that is hard to describe to people who aren't familiar with having to go through law schools or their jobs or whatever environment with that kind of factor in play. But I think it also really changed the level of activism at Berkeley at the time. Right after that post-209 time, there was a resurgence of the Coalition for a Diverse Faculty and Student Body that had been defunct because there had been strides made. And there was a sense of urgency of really holding administration accountable for the environment that we were in, and also finding a community where we can think through what coalition meant in that environment, how we can push forward while still going to classes every day and getting our JD so that we can have that broad impact. We did a conference on coalitions there that talked through there when I was a 3L. And I think it was an important part of the conversation. I think that too, what I see now going back, looking through my experience of trying to do everything I could to move us forward from that point that we were at, while still feeling a lot of really conflicting emotions about the environment that we're in. The student body at the time was, as supportive as they could be, but it was still a very different faculty there, predominantly male, predominantly white. And I think that there was a real sense that that this was a moment where we had to kind of persevere. I think looking back at that and looking where we are now, there are a couple of lessons that I picked up, at least, that I think are instructive. One is that, to echo something that Kristen said, that recruitment is going to be a big part of the conversation. And honestly, that was the real difference between my experience pre-admission at UT Austin and Berkeley, because Austin understood what needed to happen with outreach. And that was a real weighing factor for me when I was making my decision. And I think that we have to really have these conversations and tell these stories so people can't dismiss the actual impact on the folks that are in those environments struggling to, to prove our relevance to a lot of people in this space, because I think that's what kind of where we're at now. There's a lot of debate about why it's important that you have these diverse, in lots of ways, these diverse campuses, but specifically around racial diversity, specifically for me, diversity amongst Black, the Black community, because of those statistics around Black people in the profession. I have to say, I've been, it's my like my anniversary of my graduation coming up, and I have been in the workforce for a long time, and I am still in wonderful organizations that are still predominantly white-led organizations, predominantly white-populated organizations. And when I hear folks talk about the progress that we were supposed to have made in this time period, there's something that's missing. And I think that storytelling really chips away at that being the prevailing narrative. And I think it's also important that those messages be consistent, that they be unapologetic, that they be very intentional and accountable about the value of racially diverse campuses, and that we as members of these communities make it so that it stays accountable and that it stays top of mind. I have so many other anecdotes that I can talk about from my experience. I was on the admission committee. I know so much about the admissions process there and how you prepare yourself for those conversations. But I'm going to pass it over to Jarius to educate us a little bit more.
Thank you so much. I'm so glad to be here. I think a lot of the things that I'll say today, a lot of us share these sentiments. And it's unfortunate that we have to have these conversations. But my name is Jarius Adams, and I'm the national chair of the National Black Law Students Association. And our organization was formed to articulate and promote the needs and goals of Black law students to effectuate change in the legal community. So we also strive to increase the number of culturally responsible Black and minority attorneys who excel academically, succeed professionally, and positively impact the community. Now, first and foremost, I want to reiterate how utterly disappointed NBOSA is following this opinion. According to the Bloomberg law from 2012 and 2022, the number of Black attorneys and thus Black law students has decreased. It hasn't grown since 2011, and that's with affirmative action, right? And there's a student impact and then a student perspective. So in the college application journey, students take advantage of showcasing their whole selves because of their intersectionality or their genuine experience of life in this world from a unique perspective. Even with the ability to discuss race in an essay, the culture surrounding showcasing one's whole self in the college admissions selection process will change. Now, this opinion is absolutely promoting color blindness, which can be inherently dangerous to minority students. There's a potential compromise of quality of experience at universities, especially HBCUs, lessening our diverse student bodies, because the reality is, we want enrollment to go up at HBCUs, but Black folks should be able to go to universities that they want to attend, right? They may want to go to California or New York or Wyoming. Within the BOSA, we have our pre-law division, our law student division, and alumni division. And while our entire community is affected by the Supreme Court's opinion, it directly impacts our pre-law chapters because it basically is talking about admitting minority and Black students to become law students. which is the drive behind our pre-law efforts. Now, because the negative effects of the ruling disproportionately burden these smart, deserving, and ambitious potential Black law students, NABOSA's viewpoint is clear. We now have to strengthen our focus on our pre-law relationships and programming. So we recently wrote an amicus brief last October. We filed an amicus brief for the 2 Supreme Court cases that brought this forward in hopes to make our voices heard and potentially influence the outcome of the affirmative action decision. We argue that race-conscious admissions practices benefit the higher education system on a national scale, do no harm to the professional and personal well-being of Black law students, and are a critical element in creating diversity within the classroom. Additionally, we argue that race-blind admissions processes inherently harm Black applicants. I want to read an excerpt of our writing with Professor Deborah Archer. Black applicants laboring under a race-blind admission scheme will be able to point to nearly all dimensions of one's social identity, socioeconomic status, disability, sexual orientation, gender identity, or religion, except race, which in the world of the petitioners would be precluded from consideration. Even though race may be just as critical to a person of color's life and identity as these other characteristics, color blindness demands that it be ignored. It impresses upon prospective applicants of color that influence of race is meaningless and has no bearing on their candidacy. That compelled invisibility upends recognition of the entirety of one's personhood, thereby imposes a dignitary harm. So from our perspective, I think you've gotten it by now. The Supreme Court is thinking about this wrong. These are not unqualified students. These are students who are qualified, but would otherwise be looked over because of other factors, right? Race-based affirmative action is no more but a legacy-based, and even early admissions are still in place. So from a student's perspective, it shows the explicit acceptance of classism and elitism and the shunning of equity, something that many folks can't change. Now, there's a lot of gaps that we have with the Black community in access to higher education. There's an information gap. I'm thinking about the Black community, right? So there are some people who might not have gone to undergrad if it wasn't for that summer program that was funded by DEI funds, right? And that was focused on recruiting those students that are qualified but may not have access to internet in the state of Mississippi to get the information about applying to school, may not have a representative assigned to their school to let them know about scholarships and opportunities they could be a part of. Having access to that really makes a difference. And I've seen it. Everyone on this call has seen it, right? Second thing is there's the cost of college, student loans. This just adds to the burden that folks are having. It's an attack on diversity, an attack on education, but an attack on everything we believe this country can be. So what is NABOSA doing about it? We're charging our community by advising our members to ignite conversations with the respective administrations about the creation of institutional safeguards to protect diversity in admissions processes. Number 2, we're recommending that admissions offices make a concerted effort to recruit directly from pre-law BOSA chapters, HBCUs, and other pre-legal societies that are directly invested in Black college students. And finally, challenging admissions offices to create innovative solutions to incorporate diversity, equity, inclusion into not only the admissions process, but into retention practices as well. We want people to go to school and get accepted, but we also want them to finish school, right, and get their degree. So whatever we can put around and safeguard those practices so that it makes it easier for Black folks to matriculate through their time in undergrad and in law school. That's what we need to do. You know, we want them to know how we feel as they are discussing what the path forward looks like in admissions offices. we're partnering with a number of our affinity groups to put a plan together to figure out how we are going to gauge the plan that a lot of universities are going to have in place. I'm confident that a lot of universities are going to do the best that they can and do what's right. But I know for sure there are some outliers, because even with affirmative action, the numbers at certain schools are just appalling. There are many examples of things that will be impacted because of this. And the gentleman that keeps suing people over stuff that he feels is incorrect, we saw it at our BOSA chapter in Buffalo. University of Buffalo has a summer program that recruits, high school students and undergraduate students so they can get a taste of what law school is. And many of our BOSA chapters have gone through that program. And it was because of that program that they are at that institution. And we've seen attacks in that area. University of Arkansas closing their DEI office, not a good look amongst this conversation. Really, really upset about that. But we have to do our part to make sure that we are making our voices heard. So as far as next steps, we know that change won't happen overnight, but we must start somewhere. And specifically, NABOSA is curating an initiative to engage the admissions offices for evaluation of prospective efforts to enhance diversity, because we want to know what the plan is. We got the decision. It is what it is. None of us are on the Supreme Court. Now, what are we going to do to make sure that Black folks are going to undergrad, completing and continuing their education, hopefully for many of them for law school? So NABOSA will continue to work to secure the Fourth Amendment's promise of recourse as a foundation of equity and justice to make a change. So thank you for having me, and I'll hand it back over.
Thank you so much, all of you, for beginning to share that wisdom, laying out those perspectives. And I want to acknowledge that note from the Q&A. Of course, in addition to all this, there's the attacks on DEI happening at the state levels as well. So that's all in the air, but I'm going to pass over to, I want to give you all the second code for the CLE. That second code is Renaissance. And we will be very accepting on the spelling on that. So as long as you get that one. And the first one, if you missed it, was ERA. Now I'm going to pass to Markus Reneau to take us through the Q&A.
Yes, I'd like to thank the panelists for sharing their opinions so far. It's been very enlightening. I have a couple questions. Well, I have one question for each of you. But first thing that I noticed, a lot of you spoke about a concept that they describe as a critical mass. And like critical mass, that refers to an accumulation of different types of people whose presence in the organization causes changes in attitude, perceptions, and culture. And so specifically concerning critical mass, I'd like to start with Jarius. I wanted to ask Jarius, for students who go to a law school campus where they're in a minority, and as such they lack a critical mass on this campus, do you think that their experience in this institution is better served by an affinity group, or do you think it would be better served if they went to a institution where they were more in the majority?
Sure, thank you for the question, Marcus. And I think we have these conversations a lot within the BOSA because, some folks are coming from HBCUs or campuses where it's majority minority or Black, and some not so much. And we have some universities with some very low numbers, like below 10 and below 6 amount of Black people. So I went to the University of Mississippi for undergrad. So I had a PWI experience, and now I'm at Howard at an HBCU. And I believe that, there's a lot to gain from both of those experiences. But affinity groups and like our NABOSA chapters, for example, are great ways for people at PWIs to find a sense of home. I think, most of us know that people who look like each other naturally gravitate to each other, whether that's women, Black folks, sometimes when people do the same thing, lawyers, teachers, it's just a part of our nature. But one of the reasons I think that our NABOSA chapters are important, because we see what they do for students at PWIs, how it empowers them to do the same work we're doing at HBCUs, but also empowering us to not forget, right, that everyone doesn't have the luxury to be around Black folks or people who look like them all the time in classes. So I think that there's a balance of support that we can provide to them. But one of the ways that I lead within the BOSA, because I am from the HBCU, is I step up and step back. It's one of the things. I say my piece, and then I give it, let everyone else who've had different experiences speak, so that we can work collaboratively. But I think they're critically important in finding a sense of home.
Thank you for that. For Kristen, I wanted to ask you, in Justice Thomas's concurrence to the SFFA decision, he insinuated something along the lines that institutional pushes for diversity are less about inclusion and more about forming a diversity boutique for the institution. And so I wanted to know how you respond to that thought process.
Kristen, I'll say real quick. He knew not to give me the Clarence Thomas question. So I'm gonna just go on mute.
Yeah, I mean, Justice Thomas's use of interesting imagery, I mean, this is just me being my personal opinion, sort of belies a suspicion of institutions that I think has more to do with his perception of his lived experience than reality. So, I am not, and I don't think most law schools are in the business of, collecting a group of people and then patting ourselves on the back and being like, these are my blanks, and moving away from that and not providing support, to your point about people, and to Jarius's point about people graduating, thriving, being academically successful, transitioning to profession, and so on. I think it's, personally, I find it insulting, because I also think it speaks to this perception that some people hold in the world that affirmative action actually hurt people of color, because every room you walked into, someone assumed you weren't qualified to be there and you were only there because of affirmative action. And that is a very strange way to think both of yourself and of the world and the world's perception of yourself, that I don't think matches with the reality that exists in the world. Now, do I struggle, as someone who has worked nationally on DE&I issues, with schools who seem very interested in recruiting groups of people and then don't appear to be investing in the kind of programming that's supportive for those students to help them get through? Absolutely. I work a great deal in the space that's related to enrolling Native American students. There's a long-standing program called PLSI that exists at the American Indian Law Center at University of New Mexico that brings Native students together in the summer to prepare, precisely because, to your question, Jarius, they're going to go out and be the one, right? In many institutions, that will be their experience. And it is challenging when I get contacted by colleagues who say they'd really like to come and recruit at PLSI. And I think that's great, but I also worry that it's because some alumni or student group complained once and they want to appear that they have done something. And so I think all institutions could improve in this way, right? Like if we're not constantly looking at ourselves and evaluating that, it's problematic and becomes problematic pretty quickly. But yeah, no, I don't think that just matches with reality and student experience. And I think it says more about the author of that piece than it does about the practices of schools.
Thank you very much for sharing that. And lastly, I had a question for Courtney, but anybody can feel free to respond to this one. Specifically, opponents of DEI often say that America's strength is not diversity. Actually, America's strength is connecting across the breadth of our diversity. And so they use that as a way to say that I'll just focus on DEI is not necessarily helping anybody to have a better experience. And so I was just wondering how you would respond to that point about the fact that true strength is not just acknowledging diversity, but working beyond it to bridge the gaps. Does that make sense?
Yeah, I mean, I think like so many things, it's like, why not both? Like it's all, there are a lot of tactics that we need to use to get us where we need to be. And I really reject the dichotomy of like, because this thing doesn't look like I want it to look in every aspect of, then it's something that needs to be dismissed. I feel like whether it's affirmative action, whether it's DEI programs, I think that we need to acknowledge what the reality of our country's history is. We need to acknowledge the realities of the impact of that. And I really, I love the conversation about pushing back on this idea of colorblindness, this idea, this fantasy that a lot of people want us to use as a baseline. And so when I hear things like that, it makes me want to ask questions of what is your baseline? Like, what kind of country do you think we are now? And where do you want it to be? Because I think that depending on your answer, I don't think it really embraces kind of what the data says about, college readiness, about scholarships that somebody has brought up in one of our questions, and in job placement, in the environment once you get at a job, and all the way through the process. So I think that when I talk a lot about transparency and accountability as we approach solutions to this. I think we have to be intellectually honest about the value of the tactics that we're using, the value of the strategies that we want to invest or not invest in. And I think that we have to, as advocates for, a better environment for all of us, have to kind of call out the sources and the baselines that some folks purport when, maybe they are espousing a genuinely held understanding of the environment that they know, but we do have tools to talk about what the actual lived experience is and the impact of that is, and we should use it.
As if anyone else wants to respond, you can go ahead, or I can turn to the audience Q&A.
I will say one thing, and this is more than about getting into school, right? There's an impact that Black folks will feel in economics, education. We know that, for example, if tomorrow or next month I have no money to pay my rent, there's no financial wealth. My mother doesn't have it. My aunt doesn't have it. It's not there, right? And we know that education levels sometimes, or most of the time, can indicate how much a person will make, or at least what type of field they'll be in. We need more Black lawyers for generational wealth just for our community. We're not even talking about doing other type of work, but just for our community to have something to lean on. I think we'll see a domino effect of a lot of things down the pipeline, and the Black community feeling it.
Thank you.
I'll maybe just point out sort of why I think we're going to enter this era of like constant litigation. My Dean Chemerinsky said essentially, I don't know how the court's going to draw a distinction between when race is impermissible and when race is permissible, because in the majority opinion, there's sort of this very, I think, strange and untenable, almost like spectrum of awareness created, where there's a difference between knowing race, considering race, using race, valuing race. And this was part of what I think in oral arguments, Justice Brown Jackson was trying to raise, like you're actually creating a barrier for people of color who essentially have to like dissociate and disaggregate a part of themselves in a way that other people don't have to, when everything is interwoven and intersectional and sort of mutually informing. And that is the context in which we have grown and developed as individuals and as students and as community members, and in which we will become future lawyers. But I will also say that we're going to see a ton of litigation because of the little carve out created in the majority opinion, which says basically, like, of course you can consider race, and then it lays out how, and essentially says that you have to, it has to have a measurable objectives, endpoints, not rely on negative stereotypes, and so on and so forth. And there's sort of this 5-prong test. And it draws a distinction between, sort of historically that this nation has relied on race in place of relying on unique ability, specific contribution, challenges bested, skills built, and lessons learned. I think almost anyone I know, I'll speak for myself, like you can't separate those things from race. So it is the strangest idea in the world that you would be able to create an application where you redact the checkbox that someone checked and then expect not to be able to see information about their racial background, and even in this scenario to consider it. In some ways, this decision could be read extremely narrowly as an elimination of direct proxy, right? Like you can't literally be like, I will, but that was also true in Grutter. You couldn't give, points for the box that you checked or something, like nothing algorithmic, nothing formulaic, and so on and so forth. So we're just going to enter a huge era of, I don't know, but I also think that we're going to get many, many people suing law firms, educational institutions, scholarship providers, people who run pipeline programs, and so on and so forth to test the waters on this, because this is a very sort of untenable approach. The last thing I'll say too is just because we talked about recruitment and pipeline, I think you're going to see a lot of innovation from schools about things that they're doing. We're developing a completely online, asynchronous, modular, free pre-law program. Like you could come at any time. You don't even have to log in and create an account and be like, I want to watch a video about how to write a good personal statement. I want to hear from some experts about what I should be asking for in a letter of recommendation. I want to know what a first-year law class is like, because of the people who do not have the kind of access or the time or the ability to take a summer and not work and do some of the programs that exist. So that scaling and that change for pipeline programs, I think, is coming. I also think that, we did a study prior to this decision being released that asked whether or not any people with lower numerical indicators, so lower test scores and GPAs, who were not going to apply to our school, would change their minds and apply if we gave them the option to submit a supplementary video statement. So it's not an interview, it's a chance to record yourself talking about why you want to go to law school. And we found that based on sort of a mixed method study, that in fact, for people who were self-identifying as not viable candidates, that just offering the chance to provide a video statement where they felt like they could highlight something else about themselves, some other strength, churned them from non-applicants to applicants. So I think you're going to see a ton of innovation on the law school side too, some of which we may get pushback about, but I do think, hopefully institutions are not sitting on the sidelines and sort of watching this happen. Most of us are pretty deeply engaged in that work.
Yes, thank you for that. There's one question, well, a couple questions in the Q&A you kind of talked about already, just all of you have, but there was one that just came in that I think kind of touches on like a broader impact of all this. And the question is, like, beyond recruitment, what other tools can be used to address the fight against diversity in both law schools and the legal profession? And that's for anyone to answer.
I think for me, at least, mentorship is huge. And I think that it's a two-way street too, because maybe it's the time that I went to law school, but like I felt a real responsibility to pay that forward, the way that people did for me. And I think that's a harder thing to build out in a systemic way, but I feel like we need to have folks have a vision of what's possible. And from, people in my generation, a real investment in giving younger folks the resources to do what they need to do and get where they need to be and have that exposure. So I think that, there's several things, but for me, that's kind of the personal thing that I think is really important for how I contribute to this era that we're in right now.
Yeah, I think our entire organization that's what we work to do. It's in our mission. Finding ways to support us will be beneficial not only to me, but thousands of people currently in law school and afterwards. We do a lot of programming. Some of it is virtual. We have several in-person events. We're going to be at CBC doing our symposium, and we have some partners, Transformative Justice, and a lot of groups in DC in September. And we're doing our Pauli Murray Symposium at Yale. We're doing our Charles Hamilton Houston Symposium, hopefully at Berkeley. So we may need to connect all the Berkeley connects, but and then our national convention, of course, will be in Houston, Texas in March, where we'll be bringing, hundreds of Black law students from across the country together to talk about these things, get them jobs, get our pre-law students interested in law school, but enough for them to have the information and confidence to go into the LSAT. And sometimes we provide discounts. So a lot of information on our website, but that's what we're doing to kind of push this conversation.
Okay. I think that's a good place to close out. So I can just hand it back over to Taonga.
Thank you so much, everybody. And we know that this is only the tip of the iceberg. That's the pros and cons of an hour-long lunch conversation. You'll see in the chat, there's a form for feedback, and would really love anybody could share what was helpful, what we could improve on in our programming. And one theme that I heard, and I just want to lift up as we close, is Courtney lifting up that if not you, then who, which is so daunting. And I know that we all have a ton on our plate. Usually there's what's mainly going on, as well as folks' other commitments to racial justice and diversity. But I truly hope that at least all of us will in some way be able to make that change in whatever roles we are in. And appreciate you all taking this time. Hope you have a great afternoon, a great semester.